We're back on the air, we're back on the internet, and we're back talking about entrepreneurship. So this is Radio Entrepreneurs, and my name is Jeffrey Davis. And every week I eagerly await Mark Furman from the law firm of Tarlow, Breed, Hart & Rogers, who is our litigation and the law reporter. I've been talking a lot about wage and arbitration, the success you have had, the firm has had, and how important this is for entrepreneurship. Welcome back, Mark.
Hi, Jeffrey. Great to be with you. I wanted to talk about, I'm very concerned about liability of business owners under the Wage Act. I've talked about it many times. Another case that also limits the liability potential is a case decided by the Supreme Court called Mikado versus Systems 4. This was a janitorial cleaning franchise system where Systems 4 was the franchisor, and then it had another company called NECCS that was its franchisee, but the franchisor in Massachusetts. And that company, NECCS, would enter into franchise agreements with individuals to be franchisees, and the way it worked was NECCS would give customers, the franchisees would then do the work. They were their own business person. They were called independent contractors, and there was a franchise agreement that they signed. So what's different about this case, there's been a lot of franchise cases in the janitorial franchise world where it is claimed that the franchisees are employees of the franchisors. But what's different here was there was an arbitration agreement as part of the franchise documents.
Right.
So we've talked about how arbitration clauses have been given special, looked at fondly by the United States Supreme Court, and that court has held that state laws in general are preempted to the extent that they make arbitration clauses non-binding in any situation. So in this case, you have the master franchisor, Systems 4, who did not sign the franchise agreement. Franchise agreement was signed by this NECCS and the individuals who did the work. So Mikado, a franchisee, sues both NECCS and Systems 4, and he claims rights. He files it as a class action, and he claims rights to have his case and the class's case determined in court and not be subject to the franchise arbitration clause. And the case ends up in the Supreme Judicial Court, and they hold that the arbitration clause is valid both as to NECCS but also as to Systems 4, even though System 4 was not party to the agreement that the plaintiff signed. So this is really a case of extending the reach of these arbitration clauses to include someone who is not a signatory to the clause, making it very important.
If somebody else wants to deal with the mechanical side of Mark Furman, the results side versus the gloating side, how would they find you?
I can be reached at 617-218-2025 or at mfurman, Furman, at tbhr-law.com.